Jonathan Culbertson, and I am the Compliance Manager at InCheck. Today, I will be bringing you the October 2022 edition of InCheck's Compliance Update Vlog. Once again, I will be highlighting some recent legal updates that affect background screening and the hiring process. Okay, I want to start by quickly highlighting a couple Form I-9 updates that were announced on October 11th, 2022. The first is that the United States Immigration and Customs Enforcement announced that it is extending until July 31st, 2023, the Form I-9 flexibility that allows employers to virtually inspect identity and employment eligibility documentation until the employee undertakes non-remote employment on a regular, consistent, or predictable basis. The second was that the United States Citizenship and Immigration Services announced that employers should continue using the Form I-9 employment eligibility verification after its expiration date of October 31st, 2022 until further notice. Next, I want to briefly discuss some noteworthy news regarding marijuana, a new pay equity law, and an update to a previous vlog announcement. So on October 6th, 2022, President Biden announced a pardon of all prior federal offenses of simple marijuana possession and urged state governors to follow suit and pardon prior state offenses of simple marijuana possession. Additionally, the president asked the Secretary of Health and Human Services and the Attorney General to initiate the administrative process to review expeditiously how marijuana is scheduled under federal law. Now on to the new pay equity law. Westchester County, New York passed a law which makes it an unlawful discriminatory practice to, 1, request that a prospective employee disclose information about the employee's own wages from any current or former employer. And 2, for an employer to post a job, promotion, or transfer opportunity without stating the minimum and maximum salary for such position and such posting. That law takes effect on November 6, 2022. And third, as promised, the update to a previous vlog announcement. In April's vlog, I mentioned that New York City passed a law that prohibits employers from using an automated employment decision tool to screen a candidate or employee for an employment decision unless the tool has been the subject of a bias audit, among other things. On September 23rd, 2022, the New York City Department of Consumer Protection published notice of public hearing and opportunity to comment on proposed rules, which was meant, or is meant rather, to clarify the law. So it may be helpful to go check that out. And last, we will conclude with an update in regard to the California date of birth redaction decision, which has impacted turnaround times for California criminal record searches. So for background, in May 2021, the California Court of Appeals 4th Appellate District and All of Us or None of Us Riverside Chapter versus Hamrick ruled that California Rule of Court 2.507 prohibited the Riverside County Superior Court from allowing its electronic criminal case indexes to be searched using an individual's known date of birth or driver's license number. So in response to this decision, Senator Stephen Bradford introduced Senate Bill 1262, which would have required publicly accessible electronic indexes of defendants in criminal cases to permit searches and filtering of results based on the defendant's driver's license number or date of birth or both. Unfortunately, though, on September 29th, 2022, California Governor Newsom vetoed Senate Bill 2162. Well, that does it for the October 2022 compliance updates. I hope to see you again next time for some more compliance updates. Thank you.